So before we get started, just a couple of reminders. As I was typing in the chat box, the presentation today is being recorded and will be made available for future viewing. If you do not feel comfortable being recorded, your face or your name, you are able to turn off your video and you can rename yourself. You can use your initials, you can use first name, whatever you're comfortable with. We'll also be sending out the slides at a later date once the link to the recorded presentation is made available. And as a reminder, the legal staff with IowaCASA is here providing this information for informational purposes only. If you have general questions about Title IX, we can certainly do our best to answer those. However, our funding does not allow us to assist with the with consultation on drafting and implementing specific policies. So again, if you have any general questions, we're happy to answer those. What we can't do, what our grant doesn't allow us to do, is to say, yes, this Title IX policy that you've written is perfect, or these are some changes you can make, and then that would be compliant. So again, if you have any questions as we're presenting, you can type those in the chat box and we'll get to those as we're able.
So now we're going to go into a little bit of the history and what exactly is Title IX. So that's what our presentation is over, and the new Title IX regulations. And just a little bit of background, it is federal law. It's over 40 years old, so it's been around for a while. It's constantly evolving, and it protects people from discrimination based on sex in schools that receive federal funding. And it was passed in 1972. One of the main focuses of the passage of this regulation was to provide women greater access to educational opportunities, including admissions and financial aid. And in 1970, only 8% of women were college graduates, and compare that to 14% of men. That's a substantial difference. So that gap has been alleviated a little bit because of Title IX and the regulations provided within. So Title IX has helped tremendously. It has increased admittance of women into higher education institutions. And Title IX also protects transgender and gender nonconforming students. And then it's broadened the subject matter women can study. And then there's greater access to athletics, and ultimately it's led women into entering professional, technical, and other types of professions such as STEM, engineering, science, law, etc. And Title IX makes it the duty of schools to protect against sexual harassment. All right, so as you all are wondering, how is this going to relate to being an advocate or to your role as school personnel? I know we have some Title IX coordinators, equity coordinators, advocates on this particular webinar, this Zoom meeting. And so if you work in a location that has a school, K through 12, or college or university, you may be contacted by a client who was sexually harassed in an educational setting, either as a student or a teacher, and they may be seeking support. So support can include filing a Title IX complaint, which the IowaCASA legal team can help with, and we can also help with other things, which we'll go through later on in the PowerPoint presentation. And as a school employee, you may become aware of a complaint or be involved in the investigation and resolution of a complaint. So Title IX is really going to assist you in learning about those regulations and how to best serve your client. Does anyone have any questions so far? All right, we'll move on.
So just a quick note, we are using the language as it's been drafted into the policy. As we're able, we've tried to simplify that and make it non-legalese. But if you have any questions about what a term or anything means, please type something in the chat and let us know, and we can do our best to clarify what exactly that means. So the new Title IX regulations went into effect on August 14th of this year. In the midst of a pandemic, a lot of schools have put in interim procedures as they finalize what exactly their process for handling Title IX complaints are going to be under these new regulations. The new Title IX regulations, as Title IX has since the beginning of its passage, protect students against sexual harassment. And one important thing to remember is that when we talk about sexual harassment, or when you see or hear the term sexual harassment in relation to Title IX, sexual harassment includes sexual assault, rape, dating violence, stalking, etc. So it might be referred to as generally as sexual harassment, but the specific behavior may be a sexual assault. So keep that in mind as we move forward and in your work with students, either as an advocate or as a school personnel. If you read or hear the term sexual harassment in regards to Title IX, that includes those other acts. The regulations define sexual harassment as unwanted contact, which has been determined by a reasonable person, that is so severe, pervasive, and objectively offensive that it denies a person equal access to the school's education program or activity. And we'll break that down here in a second. The other form of sexual harassment that is protected against in Title IX is quid pro quo, which is this for that. So that could be a professor or a teacher telling a student, if you sleep with me, I will give you an A. That's another form of sexual harassment that is protected under Title IX. So what we'd like to do now is to just break down the definition that I just gave you, because there's a lot of different elements to it. One element is the reasonable person standard. I would anticipate that there's going to be a lot of disagreement and a lot of arguing over what constitutes a reasonable person. As people, advocates or school personnel, you're kind of trained on different things. What is reasonable to one person in their professional or personal history or experience may not be reasonable to somebody else. So I would anticipate that there's probably going to be a little bit of disagreement over that. And as a reminder, each school is going to have its own interpretation of these regulations. So there is going to be kind of a learning curve with the new regulations as they go into effect and as new complaints are submitted into schools. The other part of the definition of sexual harassment is that the behavior has to be so severe, pervasive, and objectively offensive. What this means is that the behavior, the sexual harassment, has to be severe. But it also, the word in there that I think has caused the most concern for advocates and people who provide services to sexual assault survivors is that pervasive element. That means that a one-time incident may not be enough for a student to maintain a Title IX complaint with the school. And then again, that objectively offensive phrase is kind of the same as a reasonable person. We don't really know what that means yet. And there's certainly going to be some disagreement on what objectively offensive is. So those are some areas to be aware of as you implement Title IX, or as you are working with people who have Title IX complaints or who have been sexually harassed in school. maybe those are just things that you bring up to them as possible issues. Further breaking down the definition of sexual harassment, the behavior that we've talked about, that is pervasive and objectively offensive, has to deny a person equal access to the school's education program or activity. And the new regulations define what a program or activity is. And essentially, it's anything or anywhere where the school exercises substantial control over the context of the activity and the people involved. For colleges and universities, this can extend to Greek life, fraternities, and sororities if the Greek organization is officially recognized by the school and the organization owns or controls their own building. Um, this does not include harassment that occurs outside of the US or harassment or incidents that occur if the sponsoring organization is not officially recognized by the school. So, for example, if you have a small group of students at your school who like to play chess, and so they loosely get together if they have a free period and they play chess, but they're not recognized by the school officially. They don't use any school resources. They're not mentored by a school personnel, and something happens between the two students in that chess club. That may not be covered under a Title IX complaint because the school doesn't have substantial control over this context of those meetings, and the organization was not officially recognized by the school. Does anyone have any questions so far? You can unmute yourself or you can type it in the chat box. Okay.
So next we're going to go into when a school is actually on notice. So that's when they're aware of the sexual harassment and can take action under the regulations laid out in Title IX. So the school must have actual notice before they are required to investigate. So K through 12 students may report to anyone. So they have a general way of reporting and putting the school on notice. So K through 12 put on notice if an employee witnesses harassment or hears about harassment either from a victim or third party or receives verbal or written complaints. And then post-secondary schools, so that's your colleges and just post and grad schools and things like that. The school has to designate staff. So that could be the Title IX coordinator, the Title IX investigator, or the equity coordinator, or whoever the school designates as the staff to receive the actual notice of sexual harassment. So when is a school on notice? Continued at all. So a school is actually going to be on notice at all levels when it is reported to a Title IX coordinator. So if you send any type of sexual harassment complaint to a Title IX coordinator, that means that the school has been put on actual notice. And the Title IX coordinator may be reached by phone, email, regular mail, or any other manner that results in actual notice being given to the coordinator. And the Title IX coordinator's contact information must be provided to parents, students, and applicants for admission or employment. So they must have that information in order to report any type of sexual harassment occurring within the Title IX boundaries. So when a school is on notice, the complainant gets to choose between an informal or a formal complaint, and supportive measures must be offered for either type of complaint. And then the school must respond promptly. So they may not be deliberately indifferent or clearly unreasonable in light of the known circumstances. The prompt response is not actually laid out like a deadline for that, an actual time frame. So that's discretionary, and that's up for debate, but they must respond in a prompt manner.
So we're going to talk a little bit about supportive measures right now, and kind of to give an overview of where we are in the Title IX process or complaint process. Um, right now we're at the point where a student has come to you and appropriately reported an incident of sexual harassment, and they want to move forward with that complaint. Under the new regulations, supportive measures are free, individualized services that are provided by the school to the parties, that will support them as they go through the process in order to allow them to maintain their education and to be able to equally participate in their education. As we've talked about, there's two options for a complaint: an informal or a formal complaint. Regardless of if the complaint is formal or informal, supportive measures must be offered, and they must be offered to both parties. This is a little bit of a change of what the regulations used to be. Um, and it's something definitely to think about and ahead of time for any school personnel, and how you're going to handle that if you have to provide supportive measures to both the complainant and the person who is accused of the sexual harassment. How's that going to work in your office, especially the smaller schools who may only have one or two staff um, who handle these sorts of things? So something to keep in mind. Um, when the complaint is formal, the supportive measures to both parties continue until a decision on responsibility is made. So whenever the final report is issued, the is when the school has to continue supportive measures through. Under the new regulations, the supportive measures can't be burdensome, and they can't punish either party. So what this means is that in the past, schools have been able, if they chose, to issue protective orders that tell the person who did harm not to contact the person who has filed the complaint, or who is making the complaint. Under the new regulations, any protective order issued must be mutual, meaning neither party can contact the other party, and if they do, it could be a violation of that no contact order or that protective order, and open them up to whatever sanctions the school may have available. And so if you're working with a student who has filed a complaint or is thinking about filing a complaint, I think that's something that you want to be aware of and make them aware of, is that the person that they're filing the complaint against is going to be offered these supportive measures, and they will be, if there's a no contact order requested and granted, that the person making the report is going to be expected to not have any contact with the other person. So sometimes in the middle of a Title IX investigation, there might be a criminal investigation as well. If that's the case, supportive measures are supposed to continue even if there's a criminal investigation happening and the Title IX complaint with the school has been delayed. And as I noted earlier, the new regulations state that any supportive measures can't be burdensome, punitive, they can't punish anybody. So that means that you have a reporting party and you have a party who is accused of doing harm. They may both be required to change classes or schedules. In secondary schools, it could be housing, bus schedules, those sorts of things. So something to keep in mind if you're working with a student who's going to file a complaint. There are informal options available under the new regulations. So that could be mediation, arbitration, that could be sitting down in a room with the parties and trying to talk something out that that works for everybody. Under the new regulations, the informal, um, sorry, an informal option can only be pursued if the parties give voluntary, informed, and written consent. So if you're a school personnel, you want to make sure that you have something in place for that, where and know how to ensure that the student is aware that this is a voluntary. As they don't have to do an informal complaint, they can do a formal complaint. And it would be important to make sure that you've received written consent from both parties. If the parties initially agree to pursue informal options and one of them changes their mind, they're finding that it's just not working, the person who made the report is finding that it's too traumatizing or they're not getting what they want out of it, they can change their mind and decide to pursue a formal option. That decision and that change can be made anytime prior to the final decision being issued. The school can't offer these informal options if the person who has been accused of doing harm is an employee of the school. Um, and again, as a reminder, if the students opt for an informal complaint process, the school is still required or obligated to offer supportive measures to the students. So who can file a complaint? Any person can make a report. Anyone can go to a school personnel and say, hey, I'm aware of this happening, and I'm concerned about it, or this is what I saw, or this is what I witnessed. And depending on the kind of institution that you work for or work at, that may trigger some other sort of reporting obligation, such as a mandatory reporting obligation. For secondary schools, that might trigger a timely warning under Clery. But the grievance process only begins with a formal complaint from the victim or one of these other persons who are listed here. So that means in order to actually start the complaint process with the school, the student who was harmed, or the Title IX coordinator, or a parent or legal guardian must formally make a complaint.
Chauncey?
Yeah.
There's a couple questions on here. Katie is asking, what does supportive measures look like for offering an advocate? So she's wondering if schools have to also offer an advocate to the respondent.
Well, the obligation to offer supportive measures, remember, lies with the school. The advocate is there for the student. If the advocacy center was part of the school, then or the advocates were, say, employees of the school, there's a couple programs like that, then I believe my understanding of the regulations would be that the school would have to offer an advocate to both parties. And then I see there's another question: how does third-party reporting play out? I guess I'm not sure. So I mean, I know the slide we just talked about, there are specific people who can make a formal report, and that is the Title IX coordinator or a legal guardian or a parent, or the person who was harmed. So if there's a third party who's not any of those people that goes to the school and says, this is what happened, then the school just isn't necessarily isn't legally obligated to pursue any sort of complaint process at that time. Hope that helps.
All right, can you go back one slide, Laura? Okay, so now we're going to go into the process for what happens if a written grievance is filed. So there are some things that the school has to adhere to. So parties must be treated equitably. Evidence is going to be evaluated objectively. And then no conflicts of interest, and training must be provided. And then innocence is presumed, because you have to prove that the party actually, the respondent actually committed the sexual harassment. And then time frames must be reasonably prompt, and you have to give both parties a description of possible outcomes and make sure that they're aware of the process. And then the standard of evidence, which we're going to go into a little bit later, either preponderance of the evidence or clear and convincing. Those are two different standards of evidence. And then the right to appeal must be granted to both parties, and a description of possible supportive measures is going to be both parties are going to have the opportunity to have supportive measures, and they're also going to the school has to let them know what those supportive measures are, and then just applicable privileges based on the school and the program, the Title IX program. All right, so there's some additional information that the school does have to give the parties. So it must include information about the 10 items on the prior slide, which we just went through. And then it must inform the parties if the school offers an informal resolution rather than a formal one. And then details about allegation, well, in addition to a formal one, because if they do provide an informal resolution, they are still going to provide a formal resolution as well. Some parties will have the opportunity to choose the informal option. And then details about allegation and investigation. So they are required to give the information about actual allegations and facts, presumption of innocence, advisor of choice. It doesn't need to be an attorney. A statement that parties may request and inspect evidence, and then information regarding code of conduct, and a notice regarding false allegations.
So part of the answer to Logan's question that she asked in the chat box, we'll go back a little bit. Logan asked if advocates are allowed in the room during hearings or interviews. And part of that answer was on that last slide. When a school sends out a notice that there has been a formal complaint filed, part of the boilerplate notice that goes out to the parties tells them you are able to have somebody there with you. It could be an advocate, it could be an attorney, it could be a parent, or it could be a friend. So the short answer is the student should be allowed to have some sort of advisor or support person in the room with them during hearings or interviews. And that person does not have to be an attorney. So now we've reached the point where a student has suffered harm. They've filed a report. They've decided to go forward with a formal complaint. And the school has determined that there is enough basic evidence to pursue that complaint. And now they've sent out the notice to the party that includes the information that Ashley was just talking about. And so now we're at the point where an investigation is being conducted. Under the new regulations, the burden of proof lies with the school. And we'll talk a little bit again here in a few slides about what the burden of proof is under the new regulations. Schools are allowed to say you can't talk about your complaint to either of the parties or any of the parties. That's protected under the First Amendment. They can talk about it. There may be certain confidential information or sensitive information that the school asks the students not to disperse, and that can, cause some frustration for the students who are involved. If that's a situation that comes up, it's best, I would clarify with any of your supervisors at school or advocates or supervisor at your center, or you could email us and we would give you whatever guidance that we could. And so the rest of the items on that slide just runs through what the school has to do during an investigation, and some of the deadlines that are involved as the school conducts the investigation. And at the bottom, you'll notice that we refer to mandatory or discretionary dismissal, which I think we'll talk about too here in a couple of slides. So one of the biggest changes from the past regulations to the new regulations is the requirement for post-secondary schools to hold live, real-time interviews that allow for cross-examination. Most of the school personnel on this video conference, I believe, are somewhere in the K through 12 educational system. And so for students who are K through 12, that requirement is not relevant. The interviews and information gathering can be done in writing. But for any post-secondary schools, they have to be allowed to cross-examine any witnesses or the complainant. Students are entitled to an advisor, and if they show up to a hearing or an interview without one, the school must provide one for them. The one thing that the new regulations provide that sort of protects the complainant going into what could potentially be a traumatizing experience, being cross-examined by somebody about what happened to them, is that the interview or the hearing can be done via some sort of technology, closed captioning, Zoom, etc. Just under the new regulations, what's important is that it's done live and in real time, verbally, and that the students are allowed to cross-examine and ask each other questions, or their advisors are. If a student refuses, if his party or witness refuses to be cross-examined, then the new regulations state that none of their statements are to be considered. So if a witness or a party wants to simply submit a written statement, or they get to the hearing and they refuse to be cross-examined and won't answer any of those cross-examination questions, then the school is allowed to say, we're not going to consider anything what you've told us. And it's basically like that never happened. And then the other requirement for post-secondary schools is that these interviews and hearings must be recorded. And as I mentioned, K through 12, these sorts of hearings are optional. Written questions are required, and the parties are all given an additional chance to submit any questions to each other before a final determination on responsibility is made. So for K through 12, there's obviously a little bit more leniency and flexibility. You're dealing with younger students, younger folks in general, and there's some additional considerations given for that.
So I saw a question about where the pool of advisors are chosen from. And that is up to the school to determine who is able to be an advisor. That advisor would be given by the school. So it's up to their policy. As far as the Title IX regulations, I don't think there are any limits on who can be an advisor or protocols in regards to that. So that would be determined by the institution where the investigation is taking place. All right, so now we're going to go into the standard of evidence. So just a reminder, the burden rests with the school to meet the burden of proof. So the school can choose either between preponderance of the evidence or clear and convincing evidence. Those are two different levels of evidence standards. So preponderance of the evidence, that's the lesser of the two. So that means more likely than not. So did this sexual harassment more than likely occur? And then it's also referred to the 50 plus 1%. So if it more than likely occurred, that would be 51%. If there's just a neutral and you cannot get enough evidence to say that it more than likely did occur, then that would just be 50%. So you need that 51% to rise to the level of preponderance of the evidence. And then you have clear and convincing, which is going to be a higher standard, and it's highly and substantially more probable to be true, and the decision maker must have a firm belief in its factuality. So that is going to allow for more evidence to be needed, and just more concrete a burden that is going to be your standard of evidence. And whichever standard is chosen by the school, it must use it for all sexual harassment complaints, even those filed against employees. So they can't switch up and go back and forth between preponderance of the evidence and clear and convincing. They have to pick one and they have to stick with it. So next we're going to go to, are there any complaints a school is required to dismiss without an investigation? So schools must dismiss complaints, number one, that don't describe conduct that meets the definition of sexual harassment, which we went over earlier in the slides. Number two, where the harassment did not occur in a school's program or activity. Or three, which alleged harassment that did not occur in the United States. And then next, are there any complaints a school can dismiss without an investigation? So it's may instead of must. So schools may dismiss complaints. Number one, when the complainant tells the Title IX coordinator in writing that they wish to withdraw the complaint. Number two, the respondent is no longer employed or enrolled, or if specific circumstances prevent the school from gathering evidence sufficient to make a determination on the allegations.
So somebody asked, Katie had asked about whether, hold on, I'm sorry, the chat box isn't scrolling the way I want it. Would the advocate have to act as their advisor in these situations, even if the student also had an attorney? It seems like some of the schools are saying they allow advocates in if they also cross-examine. So basically, if they're acting as the advisor versus as the advocate. I think under the new regulations, it's completely possible that a school makes an enforceable regulation or rule that says only the advisor can be in the room during those hearings or those interviews. I wouldn't want, I don't know that an advocate would want to be the advisor, because the advisor is going to be cross-examining the other person. That's, I guess, up to you. But an advisor can be anybody. It can be an attorney, it could be a friend, it could be a family member, it could be a parent, it could be a trusted, it could be a clergy member, whomever. And that person can come into the room and fulfill that role as the advisor. I don't believe that an advocate can be an advisor because of their role as a confidential support system. So I hope that helps. It's one of those things where some schools actual policies that they put into place may differ. I'm sorry, my dog is crawling over me. We were doing so well. So if you run into that situation, one, I would review the school's specific written policy in that regard, and the school should be following whatever their written policy is. If there's any questions at that point, you're welcome to contact us, and we'll help however we can. Sorry. So we're at the point now in the process where a student has made a complaint, they've gone through the process, school has conducted their investigation, they've done the hearings, they've done all of that stuff, and now the school has written their report and they've issued it to the parties. And a party looked at that report, and as most times happens, somebody is unhappy with the outcome of that report. So what happens if one, or I guess potentially both parties, are unhappy with the outcome of the investigation? Either party can file an appeal. Generally, the schools are going to have a policy regarding the timeline of that appeal and how soon after the decision is issued, the student has to file notice of an appeal. An appeal can happen at the, like I said, at the end of the process when a final report is issued, or if the school dismisses the complaint without doing an investigation. Under the new regulations, there are 3 specific grounds for appeal that a school has to include in their appeal policy, and those are listed out on the slide. The school can make the determination to add additional grounds of appeals. So different reasons why someone might ask for an appeal. But those 3 grounds that are listed on the slide are the ones that are required to be included in the school's appeal process or policy. So the regulations also dictate what the appeals process looks like. Notice is sent to the parties. They're both given the chance to submit statements. During an appeal, the person making the decision on the appeal can't be the same person who made the decision on the initial investigation. And the other important thing to remember is that, generally speaking, new evidence can't be submitted in an appeal unless it was evidence that no one could have or did know about at the time of the initial complaint process. So if you're helping someone with a complaint, um, we need to make sure that any and all evidence is submitted to the school for consideration, because if that evidence or that information is not given to the school and the student receives an adverse decision, we can't go back usually and say, oh, we had this other piece of information that the school should have known about. So that's something too to keep in mind. If you're helping somebody with an appeal, can't generally introduce any new evidence. Once the appeal is done and the decision on the appeal is made, the new regulations state that the outcome is final, meaning that, generally speaking, students aren't going to have an additional means of appealing further or asking for an additional review. As mentioned before, sometimes there's a criminal complaint that's going on during the Title IX complaint with the school. In those situations, as we've mentioned before, supportive measures must continue to be offered to the parties. In theory, under the new regulations, a criminal complaint does not change the responsibilities the school has to do a thorough and effective investigation of the complaint. It can be a little complicating if there's a criminal complaint and a school complaint going on at the same time. And that's going to depend a lot on each situation and each set of circumstances. It's possible that a criminal complaint or criminal process delays the Title IX complaint process. And under the regulations, that's okay. The school can delay the Title IX complaint process because there's a criminal complaint going on. But the new regulations state that the delay cannot be unreasonably long, and the schools cannot pause Title IX investigations indefinitely. And this is one of those things that there's going to be a lot of disagreement about. Unfortunately, there's no specific time frame or specific guidance given in the new regulations that says what an unreasonably long time might be. It's going to vary depending on the situation and the case at hand. And as going into that, there was previously, under the previous Title IX regulations, a general guideline that Title IX complaints be investigated and resolved within, I believe it was 60 days. That timeline does not exist under the new regulations. There are no set timelines or suggested guidelines for the time frame in which a school should investigate and finalize a Title IX review or Title IX complaint, excuse me.
So there are also some protections that complainants have, and we have our anti-retaliation rules. So conduct code violations not related to sexual harassment cannot be charged, which arise from the same set of facts. So say, for instance, someone was at a party where they were sexually harassed, and they're 19 years old, and they were drinking and they were harassed at that party. They cannot get in trouble or conduct code violation for the underage drinking in conjunction with the sexual harassment claim, because they have filed the sexual harassment claim, and in investigating that claim, they've actually found that they were drinking underage. So they're not going to get that additional conduct code violation because they can't be charged with something that arises from the same set of facts. And then we have our identity of the parties, which must be kept confidential. And that's a protection that complainants have. And then schools may not restrict students' First Amendment rights. and complaints must be filed according to the school's grievance procedure. So each school is going to have their policy and their procedure as to how the complaints are going to be filed and the proper protocol and protections that complainants have. And then there's also something called the Rape Shield rule. And so questions regarding sexual history are not allowed except to prove someone other than the respondent committed the harassment, or the evidence relates to consensual sexual behavior between parties and is offered to prove consent. So those are the only two ways that you can get questions regarding sexual history in.
So if you're working with students who attend a religiously affiliated school, and they come in and they say to you, "I was sexually harassed," or that they won't use those words specifically, but they describe to you behavior that may be sexual harassment under Title IX. Um, they should be made aware that religiously affiliated schools don't have to follow the same rules as non-religiously affiliated schools. And under the new regulations, students don't have to be made aware of this exemption until after they've filed or approached the school about a complaint. So basically, schools don't have to tell the students that they're not going to investigate their complaint because of religious reasons until the student goes to the school and says, "Hey, this happened to me." The new regulations also provide guidelines on what records need to be kept and how long those documents need to be kept for. Generally speaking, those documents are kept for 7 years. The school needs to keep them in a manner that maintains confidentiality and ensures that those records won't be destroyed, mutilated, or gone missing in any way. And then on the slide there's it specifies which records or documents the regulations specifically mention need to be kept. And then as we're wrapping up, just a couple of things to keep in mind, both as advocates and school personnel who care about your students and want to make sure that your students are receiving an education in a safe and healthy and equitable environment. Any complaints being filed, the new regulations kind of restrict who a student can report to, um, and have that complaint followed up on. And so if you have a student or a client who doesn't speak English, or maybe is lower functioning, or students who are so impacted by the trauma that they have problems with memory or concentration, that might be an obstacle that you'll need to work with them to overcome to ensure that they are reporting it to the right person if they want their complaint followed up on. Under the new regulations, there are no specific guidelines or deadlines or suggestions as to how long an investigation should take. So it's completely possible under the new regulations that an investigation through the school um, lasts years. And in that situation, if the respondent, the person accused of doing harm, drops out, transfers, or leaves employment during the investigation, the school is able to dismiss the complaint. So you may be working with a student who files a complaint against another student or a teacher or professor, and they go through this process. It's been months where they've gone through different hearings, different interviews, and submitted evidence, and then the respondent leaves and goes to a different school. And in that situation, the school can say, "We're done with the complaint. We're done. We're not gonna offer you any more supportive measures or anything else." And so even though that school doesn't have any further ability to sanction that student or employee who did harm, they also don't have necessarily any obligation to provide supportive measures to the student who filed the complaint. And as we mentioned at the very beginning of the presentation, the new regulations require that the behavior that we're talking about be pervasive, which means that in theory, schools could draft policies that require that there be multiple incidents of sexual harassment before they are obligated to take any sort of action.
So now we're going to talk a little bit about how our legal team can help, whether with advocacy or school personnel, or just what our grant covers for our legal focus at IowaCASA. So our grant allows us to provide legal assistance to students 11 years and older enrolled in an Iowa school. And we can help with different things, like we can file a Title IX complaint. We can assist with an appeal or the process, the appeals process. We can obtain reasonable accommodations, and we can explain options and the process of the Title IX investigation and the appeals process, and so on and so forth. And in conclusion, so each school is going to have their own interpretation of these new rules. So they are new and they're evolving. The way that we interpret them is evolving once we get more guidance. They just went into effect August 14th of this year. So they're constantly looking for ways to implement these new rules. And we would encourage you to reach out to whatever educational institutions your agency serves to discuss what changes they are making, because each school is going to have their particular policy, which revolves around the Title IX regulations and how to implement them within their own institution. And this is all very new, and the information presented is what we know today. So things may change and interpretations may vary along the way. We may get updates and new information on how these new rules are to be implemented. And if you need help or have any other questions, please let our legal department know. As we get more knowledge and we get more information and we get updates on these new rules, then we'll be able to further assist you all in your programs. But we can also answer various questions now. We're available to help. And yeah, so these are just some other sources that we have. This PowerPoint is going to be available to you all, and then this recording is also going to be posted to our IowaCASA website.
Are there any additional questions as we wrap up? Anything that we missed in the chat box that wasn't answered, or anything that you haven't had the opportunity to ask up to this point? You can unmute yourselves, or you can type it in the chat box, whichever one works for you. Okay, I'm not seeing anything in the chat box.
So where do you think, or what do you think are reasonable constraints then for us as advocates, those of us that are advocates, taking part in this process? Like, where should we limit ourselves, or should we just, because we've got schools that are implying they want us to be the advisors. We've got schools that are uncertain about what our role should be. Like, what do you think is a good line for us to draw?
Well, I think, one thing that needs to be taken into consideration is the fact that under Iowa law, victim advocates are protected under what you talk to your client about is privileged and confidential. There's a special, under the law, there's a special relationship that exists between advocates and your clients and the people that you help. That's not the same relationship that they would have with, say, an attorney or other sort of advisor who's there to um, sort of be more adversarial towards the other side. I think that it's more appropriate for advocates to remain in that position of providing support and resources um, to the clients versus becoming more of a legal um, representation or representative, because then too it's possible that advocates get into a muddy, murky area practicing law without a license. There are restrictions on that, and I think that if this comes up in a specific situation or a specific case, that's definitely something we would welcome you to email us or call us about, um, and we can provide additional guidance at that time.
Yeah, and there can also be possible conflicts if an advisor is acting as an advocate, just because the advocate usually is assigned to one individual as a client or survivor or respondent, whoever they're working with. And then if they're an advisor, then they have to cross-examine, they have to do all of those, they have to assist in the Title IX investigation process, and that could present some conflicts of interest. So you don't want to muddy those waters there, and you want to make sure that that's separated and that you can do your job most effectively for your client and for the survivor, as Santi said.
Any other questions, thoughts, concerns? I'm not seeing anything in the chat box. I've seen some people leave. So I'm going to assume that means that at this time there are no other questions. Again, just want to reiterate, anyone who thinks of questions later on or has a specific situation that comes up, you're more than welcome to email us or call us and reach out to us. We'll help in whatever way that we can within the constraints of our grant funding. So we thank you for joining us today. We appreciate it. We hope that this was helpful to folks. And again, just reach out if you have questions or concerns.
Hey guys.
Hi. That was such a good outcome, and they had such like really good questions, I thought.
Yeah. Oh, let me stop the recording. Hold on. I think the recording.